I mean, I didn't have like a grand plan to become a judge. I intended to go into politics, but not into judicial politics. I intended to go into legislative politics and executive politics, and had grand aspirations that if I told you what they are, you'd probably think I'm insane. Well, the fact of the matter is that I had hoped to be president one day. I just fell ever so slightly short of that. Chief judge was significant for sure, but it just is a little distance from president. Well, I practiced law for 9 years, and then it occurred to me that it would be a great opportunity to be on the bench. So I ran for a circuit judge position. I lost, and then I applied and was nominated and appointed to the county bench. And I wouldn't say like there was a point in my life where I said, now I'm going to start preparing for the judiciary, because that isn't the way that it happened. I had developed in a relatively short period of time a significant practice, and I'd done a lot of different things. I had done a lot of criminal work, and I'd done some civil work. I felt when I decided to become a judge that I was well qualified in the sense that I had a lot of experience in a relatively short period of time, and that this was a great opportunity to make a difference. My number one mentor and one of my favorite people ever was Judge James Sanderlin. He was a good friend of mine. Before I went on the bench, I looked up to him as a judge and a friend. I learned a lot from him. I had tremendous respect for him. And there were a lot of other judges that did a wonderful job and that I respected, obviously. But I spent more time with him and learned more from him probably than any other single judge. People want an opportunity to be heard. That's what they're generally looking for. And you have to be very respectful of that opportunity to be heard. People can take a decision that's adverse to them, but what they can't take is to be in an environment in which people use their power to cut them off, to not allow them to express their positions. And it's very important for the judiciary to be sensitive to that. I think some people think that judges don't care. Some people think that judges will not give them the opportunity to be heard, and it's very important to be sensitive to their need to be heard and to be respectful to them as human beings. And that's critical. We have a tremendous amount of power in a limited way over people. It is extremely important that we understand that power and that we don't abuse that power and that we use it only in a way and at a time when we need to. And I don't think I appreciated that. I developed, obviously, a whole different perspective when I became a judge from when I was a lawyer, and I understood what people sitting up there on the bench are concerned about. Well, obviously didn't have this wave of mortgage foreclosures that you have now. Judges over the years have become more vulnerable, and what I mean by that is with the development of the JQC, I think judges are a lot more sensitive to what they say and how that's perceived. When I was a lawyer, judges were a lot more vocal in their feelings than they are today. I think judges are very, very sensitive to those kinds of things, and that's a major change. We have a much bigger job. One of the things is that my caseload in the civil division has more than tripled in a relatively short period of time. That has an impact. So the judiciary needs to look to attorneys to come up with creative solutions rather than simply fighting all the time and coming to trial and those types of things. When I was a lawyer, we had something called a CPT, which is this giant machine, which was essentially a word processor. But I spent lots of nights in the law library, which we no longer have here, sadly, in this building, looking at books. And now I don't have to look at books anymore and haven't for years. So technology has changed the world phenomenally and certainly changed the courtroom. I can hear witnesses from different parts of the country. We do something now that we never did when I was in practice 31 years ago, and that is we have tons of expert witnesses who appear electronically. Their depositions are not read to the jury. Their depositions have been electronically recorded, and those are shown to the jury. And that obviously is much more effective than just reading the depositions. So technology's had a dramatic impact on the courts, and I suspect that will continue to be the case. I'm most proud of something that I've already mentioned, and this is sort of in a general way, which is the environment that I create in the courtroom. It is important for me, no matter how the case turns out, no matter what the case is about, that when people leave the courtroom, that they leave with a feeling that the judge that was sitting on that bench cared about what their problems were, gave them an opportunity to be heard, and thought about what the decision ought to be. That's the environment I wanted to create. That's the best way of judging. I think that's what the people are entitled to, and I believe I accomplished that, and I'm most proud of that. Well, I don't know that there are any cases that I'll be remembered for because of their legal significance. I'm sure there are cases that I have already been remembered for and will continue to be remembered for because of their peculiar nature. One of the most famous ones, of course, was the dancer who engaged in a demonstration in the courtroom. The demonstration involved showing me how she could not have turned her body the way they said she did and accomplished what they claimed that she did. That resulted in a huge photograph just at the moment when she was demonstrating this. I'm sure I'll be remembered for that. When I was doing that trial, well, first off, I'd only been a judge for like 4 months, as I recall, and I'm thinking to myself, is this what Benjamin Cardozo did when he was a judge? Is this the high point of my judicial career? And when I was looking at that girl, I was thinking, don't have any expression on your face whatsoever. Don't smile, don't frown, don't do anything, because no matter what it is, it's going to be misinterpreted. So I work, and if you look carefully at that photo, my face is about as blank as it can possibly get. And that was quite deliberate. It was what it was. They said, we want to do a view, because she was accused of exposing a certain part of her body, and they said, no, she couldn't have done it. What they described, she couldn't have exposed that part of her body, so we want to do a view. They wanted to do it in chambers. I said, oh, no, you're not going to be doing this in chambers. If you do it at all, it's going to be an open court. And I thought that they would say, no, we don't want to do it in open court, but they did. I'll probably be remembered for Puff the three-legged dog, who was a dog found in the intercoastal waterway, which generated a huge trial and a lot of litigation. And there are probably similar cases that I'll be remembered for. Those occur. I may be remembered for the battery trial of the former and now deceased U.S. Attorney Bob Merkel. I had his personal battery trial. But these aren't really of any legal significance. Recently, I sat with 2 other judges on an appeal dealing with finding the noise ordinance unconstitutional. Florida Supreme Court agreed with that decision. I also had a decision when I was in county court where I declared a statute which made it unlawful to be in possession of prescription medications outside of their original container unconstitutional, and that was upheld by the Florida Supreme Court. That case was significant because what that statute meant was that if you had to take like 10 different medications, if you took them out and put them in a separate container, that would be a first-degree misdemeanor, which meant that you had to walk around carrying 10 prescription bottles if you went on a trip or something of that nature, and I declared that unconstitutional. One fella, a short fella, came in at advisories when I was in county court, and this one short fella comes into advisories, and I said, "What is your name, sir?" And he says, "My name's Elvis Presley." And I said, "No, you're not Elvis Presley." I said his bond, and he got out of jail, and I saw him that very same day in the parking lot, and he walks up to me, and he says to me, "How did you know I wasn't Elvis Presley?" And I said, "Well, you're too short to be Elvis Presley, sir." And then I had another fella who told me that he had money to bond out if I just give him an opportunity. He had his money in a bank in Tampa, $1 million, I believe he said, is what he had, and that the Royal Canadian Mounted Police, they were coming to escort him to the bank to get his money. I didn't believe that story, of course. When I was in family law, we were doing the child support cases now that the magistrate does. Back then, we were still doing those. And I had one guy, and I don't remember the exact words, but I looked at the paperwork and I said, "Sir, you haven't been paying your child support for your children here, and you owe some significant amount of money." I said, "What's the situation here?" And he says, "Well, let me explain this to you." He says, "Now, if you have a Cadillac, a nice Cadillac, and you get to drive that Cadillac, and you take care of that Cadillac, and you care for that Cadillac. Well, if somebody takes that Cadillac away from you, you don't want to be putting gas in the Cadillac anymore." And he says, "And that's the way I view my children." I said, "Sir, this is the wrong person and the wrong judge for you to be telling that story to." But wasn't that amazing that the guy just thought he could compare his kids to a Cadillac? It didn't work out well for him, I have to tell you. I was unimpressed. I guess I've really kind of summarized it already as a person who listened to people, gave them an opportunity to be heard, and cared about their problems. Probably 5 years after I became a judge, I started teaching at the Florida Judicial College and did that every year. And then they developed a program called the Traffic Adjudication Program. And they had a huge component in there, like a day and a half involving DUIs. And they asked me if I would teach in that particular program. And when I was teaching county judges at the Florida Judicial College, I taught a segment on DUI, and it just worked well for me. And so I talked about DUI for pretty much a day every year during that program, and developed materials to use in that course, huge outlines which summarized the case law and the statutes and the rules. And some of those county judges said, "Why don't you write a book?" Rather than just confine yourself to the outline. So I contacted Wes, and they were interested in that book. It took me 5 years to write the book, and ever since then, I've been updating it every year. My wife tells people, I wish she wouldn't, but she tells people that I'm an expert in drunk driving, which is not exactly what I want to hear, but that's how my involvement in that area of the law came about. Well, I feel like I'm harping on it, but I think it's important. If you want to be a successful judge and you want to do what you ought to be doing, listen to people, treat them with respect, give them an opportunity to be heard, and care about what their issues are. And if you do that, a lot of good things are going to happen. You're going to feel good about yourself, you're going to make a huge contribution, and people are going to think you're doing a fine job because you are. If you don't have a judicial assistant who supports you, who is concerned about you, and who is concerned about the public, you're going to have problems in this job. There is just no doubt about that.